Thank you, everyone. Thank you, Professor Hawkins. Thank you to all our panelists. What an incredible panel. And now we're going to hear from some more distinguished panelists, moderated and headed by Professor Paradise. And once again, thank you to our panelists. Thank you to our moderator. And now we're going to transition to the next panel. And Professor Paradise, we'll throw it to you whenever you're ready and your panelists are ready to go.
Thank you, Michael, and thank you, Professor Hawkins and your co-panelists for such a wonderful event. I want to begin by thanking our staff at the Student Law Journal, Rutgers Race and Law Journal, for organizing this incredible symposium and everyone who's participated so far. Our panel, unlike the others, has 5 speakers. So we're going to be running on a bit of a tight schedule. And because we'll be on a bit of a tight schedule, I will limit my introductory remarks as much as possible. Our program is a little different than the other events. We'll be focused on the nuts and bolts of what both Penn State Dickinson Law School and Rutgers Law School is doing to try to reform our institutions to become anti-racist. Because the focus will be a little bit more granular, we plan for each speaker to present remarks rather than to have a freewheeling conversation. The order of presentation will begin with Associate Dean for Admissions and Financial Aid at Penn State Dickinson Law School, Bekah Saidman-Krauss, and then we'll hear from Professor Amy Gaudion, who's Associate Dean for Academic Affairs and Professor of Lawyering, and then Professor Dermot Groome, who's a Professor of Law at Penn State Dickinson. And the order of time for those 3 speakers will be divided into 6 minutes for each of the first 2, and then Professor Dermot Groome will have 12 minutes, and then we'll transition over to the Rutgers Law School side, where we'll hear from Associate Dean of the Minority Student Program, Rashida Douglas, and then finally, Professor Chrystin Ondersma, who will talk with us about some of the work we're doing as an institution to try to implement an anti-racist statement that we at Rutgers Law School adopted in the wake of George Floyd's passing and murder. So I want to begin by quickly transitioning over to the speakers since we don't have a whole lot of time, and we do want to try to preserve as much time as possible for Q&A. So apologies in advance, but if I see that any panelists are running a little bit too long, I'll be interrupting and trying to transition us over to the next speaker so we do have time for audience engagement, and I'll be monitoring the Q&A to try to pose those questions as efficiently as possible to make good use of our time. So with those very brief introductory remarks, I want to turn it over to Associate Dean Saidman-Krauss at Penn State Dickinson. Thank you.
Thank you so much. So in our effort to transform Dickinson Law into an anti-racist law school, each administrative office necessarily underwent a process of reflection, assessment, and adjustment. I'm pleased to be here today to provide a glimpse into how Dickinson Law's Office of Admissions and Financial Aid approached this challenge. Of course, for a more comprehensive analysis, I invite you to review our article, Building an Anti-Racist Law School, Leadership Determines DEI Success in the Admission and Retention of Diverse Students. My colleague, Rebecca Schreiber, and I co-authored this piece with our dean, Danielle M. Conway, whose arrival at Dickinson Law in July 2019 was instrumental in the advancements we have been able to make in the diversity, equity, and inclusion space. Hopefully many of you were able to hear Dean Conway speak on Monday about her vision to transform legal education into an anti-racist institution and the implementation steps necessary to do so. One critical aspect of Dean Conway's implementation plan at Dickinson Law is the way that she has clearly and explicitly defined her vision priorities. From the time she was hired, Dean Conway socializing her vision priorities at meetings, through email, in conversation, so that by the end of her first semester on campus, folks within the Dickinson Law community not only knew what the dean's clearly defined vision priorities were, but they endorsed them as well. Ask any member of the Dickinson Law community, and they'll tell you that vision priority number 2 means we must move the needle substantially on increasing diversity among students, faculty, and staff, with a particular emphasis on Black and African-American folks. You'll soon hear from my colleagues, Associate Dean Amy Gaudion and Professor Dermot Groome, about curricular changes and faculty resolutions adopted in furtherance of vision priority number 2. But first, let's pivot to the admissions context and talk about how my team has been able to advance this important vision priority. First, I'll note that our ability to do so goes hand in hand with our process of becoming an anti-racist admissions office and endeavoring to undo the vestiges of systemic racism present in our admissions practices. Over the past year, Dickinson Law has had the privilege of hearing Dr. Ibram Kendi address our community on 2 occasions, so I will invoke Dr. Kendi's definition here. In How to Be an Anti-Racist, Dr. Kendi explains, one either believes problems are rooted in groups of people as a racist or locates the roots of problems in power and policies as an anti-racist. One either allows racial inequities to persevere as a racist or confronts racial inequities as an anti-racist. There is no in-between safe space of not racist. So ABA and NALP data show that Black and African-American folks are disproportionately underrepresented in law school, the legal academy, and the legal profession. If we apply Dr. Kendi's definition to the law school context, the question is, are we going to allow this racial inequity to persevere as racists or confront this racial inequity as anti-racists? Dean Conway's vision priority number 2 seeks to confront this racial inequity by addressing a real gap in representation. As we attempt to address this representation gap at the law school level, we must understand the various challenges that admissions offices face in the recruitment context, including disparities between white and racially minoritized applicants with respect to pool volume, timing of applications, and quantitative metrics. At Dickinson Law, we've utilized a variety of data-driven strategic solutions as part of a layered approach to addressing some of these challenges. This multi-pronged approach helped us yield our most recent 1L class, which was comprised of 44% students of color, more than doubling the percentage of the previous year. As an example of one layer within our multi-pronged approach, I'd like to talk briefly about scholarship allocation. In our effort to identify admissions practices that resulted in disparate outcomes or inequity with respect to race and ethnicity, we closely examined our historic scholarship data. Our assessment revealed that on average, white students received higher merit awards as compared to students of color. Seeing this variation borne out in the data helped our team to adjust our approach. We realized we had relied more heavily on quantitative aspects of our holistic review as compared to qualitative measures. We have actively worked to confront this racial inequity and correct this scholarship disparity by placing greater emphasis on qualitative aspects of our review and by considering an applicant's successes relative to the personal challenges they have faced. From fall 17 to fall 20, we have significantly closed the gap between the average institutional scholarship offered to students from minoritized racial and ethnic groups as compared to white students. Of the various examples included in our paper, I think that this one is especially significant because of the impact that scholarship offers have on yield, on student debt, as well as their connection to the racial wealth gap. Our prior practices, however seemingly innocuous, were perpetuating racial inequity, which we are now working to correct by reframing our awarding practices. Indeed, this strategy is one that has worked well for Dickinson Law, but there are many ways to do this important work of cultivating an anti-racist admissions office. Now my colleague, Amy Gaudion, will discuss how she was able to operationalize an anti-racist curriculum at Dickinson Law in her role as Associate Dean of Academic Affairs.
Thank you very much, Dean Saidman-Krauss.
Can everyone see my slides? Professor Paradise, are we good?
Yes, we're good.
All right, wonderful. Well, thank you all. First of all, thank you to Professor Paradise, to Deans Mutcherson and Lopez, and to the Rutgers Race and the Law Review for hosting this symposium and this important discussion today. For far too long, law schools have been part of the architecture that enables and perpetuates racism, whether through action, inaction, or blind adherence to a hopeful but misguided understanding of the law as a neutral arbiter. Many scholars have offered compelling contributions demonstrating the need for law schools to realign, to re-envision their legal curriculum. And indeed, that demonstration is well documented and in my view, undisputed. So the question here today is not whether law schools should adopt an anti-racist curriculum, it's how to do so. And my hope today is to start to answer that question and to do so in a way that provides an honest account of the unglamorous administrative work required for that task, and to offer a roadmap to those who take on this important project. I want to make 3 important points today. First, the importance of being precise about our commitments to become anti-racist educators, and to use our words of commitment and our words of resolve as centering mechanisms for the implementation work ahead. Second, I want to acknowledge that curricular planning is comprehensive and continuous. And building on the discussions from the last panel, it's not one course, it's not one program, it's multiple touch points across the curriculum. Third, I want to talk about the importance of recognizing the need to equip our faculty and our staff with the tools to deliver on the promise of anti-racist education. Let me turn now to my first point. Our path at Penn State Dickinson Law started, as did many other law schools, right? With words, with statements. In our case, we had the statements from students as well as statements from faculty. And the first point I want to make is that we need to use these statements to center our work going forward. At Dickinson Law, this means 2 things. First, it means that we need to be precise about articulating what our students have asked of us, and equally precise about what we've promised in response. For example, our students asked us to, quote, provide measures and opportunities to acknowledge and discuss the injustices that go on in the US and biases that occur within the law school community. They asked us to consider curricular reforms, faculty training, and pro bono initiatives, and they asked to be involved in the planning. In response, among other commitments, we promised to be active anti-racist. We promised to be accountable for doing the work necessary for policy change. And we promised to incorporate more opportunities for students to learn about and discuss racism and inequality in the classroom. The second idea or takeaway from this centering mechanism is to make sure that you're returning to it, that you're returning to those words of commitment that you made during faculty meetings, during memos about committee charges for the year ahead, during ad hoc committee meetings. That's what it means to center your actions based on those words of resolve. Let me turn now to my second point. This is recognizing that an anti-racist curriculum and anti-racist curriculum planning is comprehensive, it is continuous. It should involve multiple touch points. As you can see here, we've identified 4 at Penn State Dickinson Law, including a first-year course that my colleague, Professor Groome, will speak more about shortly, including a JD degree requirement that students take at least 1 upper-level course with a subject matter focused on civil rights, equal protection, or social justice. Those are both required elements of the JD degree. But in addition, we've built in elective options, right, for students who want to pursue a certificate in civil rights, equal protection, and social justice. And of course, the smaller but equally impactful idea of small teaching touch points, those moments in classes and in programs when we can engage with this material. For purposes of this slide and my article, I've differentiated these touch points. In practice, however, they are iterative, supporting and building upon one another, and they provide materials and content for multiple uses and applications. Let me also just pause here to note the speed with which the faculty at Penn State Dickinson Law put these curricular forms in place was admirable. We did so over a 5-week period during the summer, but it's also revealing. It was as if we all understood the need for adapting an anti-racist educational posture, and we already had a solid sense of what the pieces were. We lacked, however, the vision and impetus to acknowledge our individual obligations as legal educators to implement such change. And although too long in coming, the events of the summer, right, and those leading up to it, and the vision of our dean moved us into this implementation space. Let me turn now to my third and final point, and I'll get all of these up here for the sake of time. promises of change have little worth if those making the promises do not have the ability to deliver on them. And it quickly became apparent that while the words of the faculty resolutions were sincere and the curricular design was solid, there was some work to be done in meeting the promise of becoming anti-racist legal educators. Let me pause here to speak specifically to the administrators among us, those sitting in the Associate Dean of Academic Affairs or Associate Dean of Student Services positions. As administrators, we contribute to this effort by creating the space, the time, and the medium for listening and learning. We also take care of the tedious and unglamorous, but equally important scheduling, logistics, and technical tasks associated with ensuring our colleagues have the space, time, and means to engage in this important work. Some of the buttons here indicate mechanisms to do this. And I have an article that I'm contributing to the symposium that goes into detail about each of these. Let me just talk about the first one briefly, and then I'll wrap up. Embracing bureaucracy. Right? There's no way around this point. After the powerful and moving words have been written, and the symmetry and the grace of the curricular vision has been framed, it's time to embrace the burdens and the tediousness of faculty governance processes, ad hoc committees, draft proposals, wordsmithing arguments with your colleagues, right, and administrative bureaucracy. In short, it's time to attend meetings, and I mean a lot of meetings. I want to make this point because it's an important one. It's difficult to quantify the amount of time invested in these efforts, but this time commitment is a necessary part of the task of building an anti-racist curriculum. Do not ignore it, do not deny it, right? Acknowledge and embrace the investment of time and energy that's required, and recognize the personal and institutional growth and sense of shared purpose that comes from the intensity of that bureaucratic effort. And again, maybe in the question and answer session, I can speak to some of the other mechanisms here that go to the point of equipping our faculty and staff with the tools needed to deliver on that promise.
Thank you, Dean Gaudion. We generally will wait for Q&A to pose any questions, but we had a really targeted question in the Q&A. Can you please tell us how many credits the first year course Race and Equal Protection of the Laws is?
Sure, let me go back to that. Wait, did I skip that? There it is. So the first year course is 1 credit. It goes across the entire year, and it's split up as half a credit each year. And I know Professor Groome will speak in more detail about that course.
Okay, wonderful. Thank you so much. Professor Groome, I hand it over to you now.
Just 1 second, let me get my screen up. Okay. So the Penn State Dickinson law community has worked very hard this past year to develop Race and the Equal Protection of the Laws program. We know that other schools are trying to develop similar programs. I want to begin by extending an offer from Dean Conway and Penn State University to help other legal educators in their efforts. If you think you can learn from what we have done, or that our work can help you if you are developing a similar program, we are committed to supporting you. The best way to introduce the program is to let you hear from one of the students in it.
Hello, my name is Mallory Turner, and I'm a 1L at Penn State Dickinson Law. I want to talk about our Race and Equal Protection of the Laws program. Before we tackle racism, we must first identify what it is. And that's what this class does. It shows the history of the creation and implementation of racist laws, especially in the areas of housing, health, capitalism, and education. This class will make me a better lawyer because I was able to have difficult conversations with my classmates, and it created a basis level of understanding that is essential for our legal profession. I'm also personally grateful for this class because I began law school during a racism pandemic, and this class helped me to feel seen and supported. So thank you.
We started the program in September 2020 as a 1 credit, year-long, pass-fail course that all first-year students are required to take. REPL explores with students the relationship between race and our legal system and engages them in sometimes difficult conversations about it. I realized that if we wanted REPL to cultivate within students a principled, enduring commitment to work for equality, we had to do more than simply teach them substantive legal principles. We had to help them reimagine their role as lawyers and help them discern their own personal response as a legal professional in the world of today. I turned to critical pedagogy for help. Critical pedagogy was conceived by a Brazilian lawyer by the name of Paulo Freire. His foundational work, Pedagogy of the Oppressed, published in 1968, explored the relationship between education and social justice. Critical pedagogy's essential insight about education is that one of its goals should be to create an opportunity for students to be able to reflectively frame their own relationship to the ongoing project of an unfinished democracy. Most of us do not have scholarly expertise related to race or the 14th Amendment. What would Freire say we should do as legal educators at this moment in our country's history? Freire calls us to work as co-investigators with our students and explore the relationship between race and our respective fields of law. To ask within the context of a UCC class or a health law class, 3 important questions. How is the law reflected in the lived experience of different groups of Americans? For example, do all American children have comparable educational experiences? Second, what are the root causes of the different lived experiences between groups? Could one of the causes be that the resources available to schools are determined by local property taxes? Is it good for our country to have such educational disparities? Third question, what are the possibilities for change? Should we rethink how we fund schools in order to provide uniform, high-quality education to all American children? Wouldn't that also give our country a competitive advantage in the world economy? So how did we at Dickinson Law adapt the objectives and principles of critical pedagogy for a law school curriculum? The first step in preparing a session where these questions will be posed is to identify a generative theme. A generative theme, for our purposes, is an important life issue involving both race and the law that we want to examine with our students. For REPL, we identified 7 generative themes that relate to the relationship between race and different areas of our legal system. There are certainly others, and it is our intention to develop additional sessions in the future. When the day of the session arrives, we begin by bringing the generative theme into sharp focus. We call this turning our attention to the issue. For this segment, we try to find a 5 to 8 minute video that helps students turn their attention from their other obligations and focus on the important life issue of the session. For our first session on historic and modern privilegia, we used a video of Frederick Douglass's descendants reading his famous speech, "What to the slave is the 4th of July." For capitalism, we played a news item about discriminatory lending practices of the Department of Agriculture. For criminal justice, for race and criminal justice, Campbell Goyne, a 2L student, described an interaction he had with the police as an 8-year-old. After the turning our attention to the issue segment, we move into the lesson segment. In developing the course, I thought, how can we engage students in a critical reflection on race and the law when they, like me, probably don't know enough about race in our history to have an informed discussion about it, to think critically about it? So the lesson segment seeks to impart some basic knowledge about race in our legal system within our American historical context so that students can have an informed discussion about the generative theme. The lesson segment includes several presentations on specific topics. Wherever we can, we try to trace the path of historical phenomena to their vestiges in contemporary American life. Here, Professor Battersea described the use of slaves as collateral for loans and draws comparisons to modern financial instruments. Students have played an essential role in designing and delivering these lessons. Here, Samantha Jacques, a 3L from Atlanta, Georgia, gave a lesson she developed on the Fugitive Slave Act. After the lesson segment, we moved students into small discussion groups to discuss a prompt related to the generative theme. During this process, we are trying to achieve two objectives of critical pedagogy. The webinar that there's a link the organizers have provided, that webinar explains this segment and others in greater detail. But let me give you an example. Here for our first session on historic and modern privilegia, we asked students to work jointly to write an internet review, an Airbnb type review of our Constitution. Has it lived up to the advertised promises of its preamble? Has it created a more perfect union? Does it ensure domestic tranquility? Does it promote our general welfare? And if you read the subprompts in blue, you will by this time recognize their connection to critical pedagogy. What is the group's assessment? What are the root causes? What needs to be done to correct problems? The webinar also includes student reactions to the group discussions. Each session has a segment we call the story and vision. For this segment, we invite a featured speaker to address the students on a generative theme. We try to find someone who can speak with both authority and authenticity about the particular issue. We invite them to share their own personal story related to the theme of the issue. We invite speakers to tell students about any relevant research they have done. During our race in the healthcare session, Professor Chiara Bridges described a study she conducted at 2 New York City hospitals. She also wrote a book on critical race theory. She helped students look at healthcare through that lens. We invite our featured speakers to talk about how the law can be used for change and their personal story of how they have responded to inequality using the tools they have as lawyers. We also invite them to share their vision for the future in a way that motivates students to reimagine their own potential to be agents of change in our country. For our session last week, we were fortunate to have Professor Deborah Archer, the president of the ACLU, speak to our students about race and democracy. For each session, we produce a handout. It averages 30 pages and seeks to supplement the session in several ways. I will leave it for the webinar to describe the individual components of the handout. So that's Dickinson Law's Race and the Equal Protection of the Laws course. Let me conclude with another student's reaction to the course.
Hello, my name is Zainab Aliyu and I'm 1L student at Penn Sate Dickinson Law. The Race and Equal Protection class is not a class I was expecting to take before I started law school, but it has turned out to be one of my favorite classes and a class that I constantly look forward to. As a triple minority, I find that most people do not understand my struggles. They don't understand where my voice is coming from. They don't even understand how flawed the American legal system is because it works exactly the way they want it to for them, but not for me or for people that look like me or dress like me or behave like me. This class has a holistic approach into the framework of the American legal system. It also emphasizes proactive measures students can take into fixing the system as we become young lawyers. It starts to develop character in students, where in the sense that in like 5 years from now, I'll be able to look back at this class and know that whatever I've learned from this class, I can apply it into the real world because we talk about real world issues from a historic point of view and from a current view of the world. This class, I think this class needs to be a GE requirement because it's a very educative class that prepares lawyers to start fixing the system, to start taking proactive measures to ensure the system does what it's supposed to do. I really appreciate my school adding this class to our schedule, and I recommend it to other schools because I think it's an amazing class that has prepared me into becoming a better lawyer, into a better and empathetic lawyer, and has given me the ability to learn from my peers and also grow. Thank you.
If you are interested in learning more, take a look at the webinar that's on our website and has been circulated in this conference. If you know of colleagues in other law schools that might be interested, please tell them about the program and our offer to help them develop similar programming. In my view, there are two professions that can best lead us forward from this very difficult moment in our country's history, a moment with existential implications. The two professions are teachers and lawyers. Dear colleagues, we are both. So let's work together collaboratively to educate a generation of lawyers who can help our country make long overdue progress, to help our American legal system evolve in a way that fosters true equality in the lived experience of all Americans. Thank you.
Thank you, Professor Groome. That was a wonderful presentation. I certainly would have liked to have taken a class like that when I was in law school. We're now going to move on to our Rutgers panelists, beginning with Dean Rashida Douglas. But before we do so, I want to let all of our audience know that each of the speakers we've heard from will be publishing a piece with the Rutgers Race and Law Review. So please stay tuned for those publications, which I think will help to further our understanding of these issues. So now over to you, Dean Douglas.
Thank you so much, Brandon. And it was such a pleasure to hear about what is being done at Penn State Dickinson. I definitely applaud you all on the great strides that you've made already. It is my honor to speak with you all this afternoon about the Minority Student Program. And I just want to share my screen, so just give me one moment to do so. Okay, I'm sorry, give me 1 minute. Okay, just to give you all an idea about what we're going to be learning about today, it's a nationally renowned program that Rutgers Law School started in 1968. And the program is not an admissions program, it is a post-admissions program that has effectively changed the face of the New Jersey legal profession and beyond. And so this afternoon, I'll be speaking to you all about the Minority Student Program, also known as MSP, regarding its history, impact, and legacy. And so just to give you all an idea of what the legal profession looked like prior to Rutgers Law taking a visionary and transformative stance and helping to ensure—
Excuse me, Dean Douglas.
Yes.
Our audience cannot see your slides. If you could try to reshare the screen.
Yes, 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 sorry. Thank you so much, I apologize for that. Okay, I have a new laptop, but that should be good to go now. Can you see it now?
Yes.
Okay, great, thank you. Sorry for the technical difficulty. And so I'll just go back to what I'm saying a minute ago, just to give some context to what was occurring within our nation, what the New Jersey legal profession looked like prior to the creation of MSP. So between 1960 and 1967, there were only 12 non-white students that graduated from Rutgers Law. Just to give a broader view of what was happening within the state, as of 1969, there were fewer than 60 African-American attorneys who were actually practicing out of the 8,000 that were practicing in the state of New Jersey. And there were even fewer Latinx and Asian American attorneys at that time. And as we all can recall, during the 1960s, especially the later 1960s, there was rebellion throughout the United States and several of our major cities regarding the marginalization of African Americans and other communities of color. And the Minority Student Program was actually created on the heels of the Newark Rebellion that happened in 1967. Interestingly enough, that rebellion was started as a result of an act of police brutality that occurred in the city of Newark, as well as the ongoing marginalization of the African American community in that city. MSP was created in 1968 by Rutgers Law faculty and students. Its initial focus was to bring an increase in the number of African American law students. Over time, the program has expanded to also focus on increasing the number of Latinx and Native American as well as Asian American law students. Just to give an idea of the impact that MSP made in a very short period of time, by 1971, 3 years after the creation of MSP, there were 101 Black students enrolled at Rutgers Law in Newark, which was approximately 20% of the student body at that time. And in its current mission, it has also been expanded to accept students of all races and ethnicities who've encountered significant social economic challenges on their journey to law school. We have seen a significant increase in the number of LGBTQ students who are now at Rutgers Law School, as well as white students who are from low-income backgrounds who've had to overcome significant challenges on their way to law school. In 2016, MSP has actually been offered as well at the Camden location as a result of the merger of the two law schools. To date, the alumni base of Rutgers Law is close to 3,000. Many of the MSP alumni have become leaders within the bar. They're members of the judiciary, leading law firms, leading public interest agencies, and can be found in several different leadership roles throughout the state of New Jersey and beyond. And so what are the components of MSP? The main focus of MSP is to create community within the law school. Like I'm thrilled about the changes that we're going to see to our curriculum and in other aspects of the law school. But the minority student program is essentially created to ensure that students feel like they belong. There are numerous studies that talk about how law students who are from underrepresented groups often don't feel like they belong in law school. So outside of the classrooms, we're talking about engagements with other students, whether or not they're represented in student leadership roles, and whether or not they have the tools that will essentially help them to transition into the legal profession. And that's where MSP has come in and played a critical role. So what we have provided to 1L MSP students, we do orientations. This occurs prior to the start of the fall semester so that students can already start building relationships, building that community that they're going to need to lean on, during those moments of self-doubt or different feelings that law students will have during their first year. The law students that participate in MSP often remark that the orientation sessions just help them acclimate to law school, to feel like they already had a community before stepping foot into the law school class. The other thing we provide is academic support. 1L MSP students are placed into study groups during their first semester. Those study groups are led by upper class MSP students that, again, can help these students understand how to navigate law school, in addition to exam preparation, outlining, and other aspects that they'll need to know for law school. The other component of MSP that's critically important are the mentors that we provide. We provide an upper class MSP student. We also provide them with a practicing attorney. We want the law students to understand the value of relationships. Most students that are from underserved communities do not have the social capital that they need. They don't have uncles and aunts that are judges or that can put in a phone call to a law firm. So we're helping them to develop those key relationships while they're still in law school. What we also provide is a summer internship program. In Camden, we actually assist them with applying to summer diversity programs, but at our Newark location, we have about 30 law firms that in government agencies that agree to take MSP students every summer as 1Ls. As you all remember, the summer after your 1L year is especially challenging to actually secure employment. So this is another key to that building block to, again, helping these students to actually successfully transition into the legal profession. And so what we've also done is we've expanded the support that MSP provides for those law students that don't actually score really, that don't achieve the academic GPAs that they would need to be competitive for law firms. We've also provide a judicial internship stipend, and that's to help students who intend to pursue judicial internships during the summer, which again will help them develop their writing skills, their research skills, and provide a mentoring relationship, which again can help them start to build the social capital that they need for success. We also provide book stipends, and these are funded by alumni. We have law firms and we have other supporters that give to this fund in order to help offset the cost of books for our MSP students. What we also do, we do other collaborations throughout the fall semester, and we even start some of these collaborations in the summer. We partner with local law firms. We also partner with local corporations to bring MSP students into those spaces so they can start to envision themselves there as practicing attorneys. We help also speak with different bar associations that, again, can provide mentoring. We conduct mock interview workshops for our MSP students, again, to help them in transitioning and understanding what they're going to be preparing for with summer internship interviews. In addition to area law firms, MSP has been a point of contact for members of the judiciary who are looking to increase diversity within their applicant pools. So these are all key contacts that I feel a standalone program like MSP allows law schools to make with employers, with alums, with organizations that are interested in increasing diversity and inclusion within their ranks. It's been an excellent model here at Rutgers Law School. And so we also have extended our pipeline efforts because we want to make sure that underserved students understand what it takes to actually be admitted to law school. That's not something that students who are the first in their families generally know. So at this annual conference that we provide specifically to underrepresented undergraduate students, we help them with the law school admissions process. We talk to them about how to compile a strong application, how to draft a strong personal statement, how to study for the LSAT, and also how to finance a legal education. This is a one-day conference that we have now provided to close to 400 underrepresented undergraduate students. What about the ongoing impact and legacy of MSP?
Dean Douglas, can we wrap up in about 30 seconds or so?
Absolutely, I'm almost done. Thank you, Brandon. Just to look at the class composition of the class that we just brought in last fall, 35% of our students were students of color. My colleague, Jay Austin, will be speaking tomorrow further in depth about the admissions processes that we use. And then last but not least, just the ongoing legacy of MSP. As we can see here, the Hispanic Bar Association recently released a press release about the women who were actually noted within a local business journal as being 50 of the most influential women within the state of New Jersey. Those women included Judge Esther Salas, Camellia Valdez, Anne-Marie Tejada, and Melinda Cox-Colon. All of those women are MSP alumna. In addition, we have a MSP, a recent graduate who recently received a Fulbright Fellowship. So this is just an example of some of the leaders that have come out of MSP. Thank you.
Thank you so much, Dean Douglas, for reviewing the groundbreaking revolutionary work Rutgers Law School has done to transform the state of the New Jersey bar and to further diversify it. I want to mention that one of our colleagues, Paul Trachtenberg, wrote a book entitled A Centennial History of Rutgers Law School in Newark, Opening 1,000 Doors, which reviews the MSP program in more detail. While Professor Ondersma is speaking, I'll put a link to that in the chat for anyone who is interested in learning more about the history of MSP and our efforts to transform the New Jersey bar. So to you, Professor Ondersma, we go now. Thank you so much again, Dean Douglas.
Thanks so much to all the panelists, both on this panel and previous panels. It has been really so exciting to hear from so many different schools who are embracing the idea that our current legal curriculum is not sacrosanct and that there is a possibility to really expose all our students to critical race theory, a possibility that our law schools can take seriously the idea that we can equip students to both recognize the law's role in perpetuating white supremacy and then begin to interrupt and dismantle institutional racism. So it was really exciting to hear about the work that everyone's doing. I actually want to use my time to talk frankly about some of our shortcomings so far and the work that is still ahead of us. Many of the things that I'm going to talk about have already been raised by previous panel members. So just some history. We also in the summer passed a faculty resolution on Black Lives Matter and our commitment to anti-racist principles and action. And this statement included really bold language and very specific commitments. We said that we called upon all to recognize that our nation's laws and legal institutions have too often protected and reinforced the white supremacist status quo. We said that we want to ensure all of our students as future lawyers understand how individual and institutional racism impacts every aspect of our legal system and acquire the knowledge and skills needed to take an anti-racist approach to combat racism in all its forms. We also committed to fighting for meaningful structural change on behalf of racial justice, even when it's difficult, uncomfortable, and risky, and even when it requires sacrifice. So those are bold things that we said, and we did get to work right away, but I wanted to talk about just the challenge and going from recognizing and agreeing that these things are important to moving to implementation. So Dean Mutcherson did a lot of work in getting us going and organized. She had also spearheaded, along with Dean Conway, the Anti-Racist Clearinghouse audit, which I'm sure folks are already aware of. But so we have a bunch of committee work going on starting in the summer, including collecting demographics, data, looking also at issues of inequities in scholarships, admissions, equity issues among faculty, staff, and administration, getting information about student experiences, career development work, and then also the curriculum committee, of which I am a member. So I'm going to focus on curriculum committee work because that's what I mostly worked on so far. So, also faculty attended some trainings. We participated in the New York area law school anti-racist consortium, and our clinical and skills faculty have been actually doing a ton. They attended a whole week-long course on undoing racism, and they've been meeting bi-weekly. So they have been really deeply engaged in this work. So far our curriculum committee has just draft proposals, but we haven't settled on one yet. We are going to look into implementing an upper level equity requirement and a 1L mandatory course, but we haven't finalized the proposals yet. And we're still working through some challenges. I think one challenge just overall, which I'm sure all of your schools have dealt with, is this idea of what do we mean by an anti-racist education, right? Are we talking about, because critical race theory is different from just acknowledging a problem of racial justice, right? Of racial injustice. So faculty have all kinds of different ideas about what this means. We said in our statement that we commit to recognizing law's role in furthering white supremacy, and we committed to helping to equip our students to really interrupt racist institutions. And so that's a bold goal. So I think that many faculty that are wanting to incorporate issues of race are doing something different than taking necessarily a critical race lens. And not all faculty may be on board with taking a critical race lens. So then, at least in our equity and 1L courses, maybe we do take that approach. That's one question. But another challenge that I want to talk about is the disproportionate burdens on faculty and students of color. So take, for example, a first-year mandatory class. Who will teach the first-year mandatory class? Guess who on our faculty has the most experience and is best equipped to teach it well? Usually it's faculty of color that are already disproportionately burdened. Also, if it's a mandatory course, that means that students are going to be in the class that don't necessarily want to be there. So does that disproportionately burden our students of color that then have to be in a class where white students might be saying hurtful or clueless things that can do a lot of harm? So there's just so much need for deep and ongoing training, right? We have to make sure that faculty can facilitate discussions about race and have the skills to do it. So especially because if we're really talking about an anti-racist curriculum, right, the goal, I think, would be that it wouldn't just be 2 courses where people are thinking and just discussing issues of race. But, in order to really do that well throughout the curriculum, we just need so much education, and myself included. I think of my own shortcomings. For example, I teach consumer credit, and I spend a lot of time talking about the disproportionate impact on Black and Latinx students. I don't talk at all, I don't think, about the impact on Indigenous communities or Asian American communities. And that's something that I need to do a lot more work. And other intersectionality issues, like I don't do anything on ableism and intersection of disability and race, and also gender and sexuality. It's just so much. And so I need tools. I know the rest of my faculty needs tools to do this. So although we have had some work, we really have more to do in terms of education. And I love the idea of mandatory CLE on critical race theory, but then also we could have mandatory CLE just on tools. There's a lot of people that are experts in how to create, a brave space as opposed to a safe space, how to interrupt incidents, harmful incidents when they occur, and just how to set the stage at the beginning. And then also equity issues, how to make sure that every student in your class feels that they have the capacity to be the best in that classroom. You want every single student in your classroom to feel that they could get the A+ on the exam. How do we create an environment where that is possible? So these are just hurdles. And, you know, we have all been working so hard. Many of us have been working so hard. And again, as other folks have mentioned, these burdens have not been shared equally on our faculty. And, you know, we're making progress, but there just is so much work to do. Our students have been doing so much, our Black students in particular, and other students of color have been doing a lot to help, you know, guide faculty, teach faculty. They've been serving on these committees, and I think they're frankly exhausted. So we want to have a major faculty orientation at some point in the fall that give faculty tools, immediate takeaways for their classes. So that is one thing that is next on the agenda. But this has to be ongoing work. It can't just be one training that faculty attends. You know, faculty need to be really prepared to put in the time. And again, I'd say this, acknowledging my own work, tremendous work that I still have to do. So thank you all very much.
Thank you, Professor Ondersma. So we have a little under 10 minutes left for our time together, but I do want to take moderator's prerogative and pose a question of my own. So one of the themes that came up in the prior panel, the Professor Anthony Farley focused on, is the great distance between the vision of an anti-racist, beloved community that Dr. King is so famous for, and the society we actually have, including the shortcomings of our institutions of legal education. Professor Ondersma, you focused us on some of the challenges we've had at Rutgers Law School. And one of the questions in the chat, which is connected to my own concerns and questions, are what can we do? And maybe if Penn State Dickinson can weigh in on this, what have you done to try to address some of the barriers to implementing reform? Off the top of my head, two of the things that emerge are the conceptual difficulties around defining what an anti-racist institution is. And you're going to have lots of contests around that, including on issues like academic freedom. And that's such a complex inquiry that we're not gonna be able to address it today. We could have a whole separate panel on that. But it could be addressed maybe in brief. And then the second issue is resources, right? So if we wanna have mandatory CLE training, if we want to expand offerings around anti-racist curriculum, then we're also, as mentioned by multiple speakers, going to have in prior panels, going to have more hiring. And so we have both conceptual challenges, contestations around what it means to be anti-racist. Then we have an issue of resources, especially in an era of increasing austerity in legal education. How do we effectively deal with the great racial inequity that continues to characterize all of our institutions? So I threw out an awful lot there, but if anybody wants to take a first pass on it, please do, and then I'll get to questions in the Q&A.
Yeah, I'll try and jump in and just offer one comment and then I think one suggestion. And the comment is I fully appreciate the definitional debates, and I think they're critical, and I fully appreciate some of the resource constraints. They need to be addressed, but I do worry sometimes that those are put up as roadblocks, right, to actually moving forward. So let's be honest and candid about that when those things come up, and make sure that they're not just being put up to kind of pause, right, or delay the larger initiatives. Second point is they are critical. And one of the things I talk about in my paper is recognizing, right, and I don't have any, there's a number of different ways to address this, but recognizing, again, the disparate impact on our colleagues, faculty and staff, and our students when we do these things, and then think about how, when we're calibrating that balance, how do we recognize it? How do we do it correctly? On the faculty side, that's in my wheelhouse, right, is really talking about equitable and sustainable workloads for teachers and for faculty. And that's not an easy discussion to have, and it's we've been slowly working on it, and it's so tied to putting into place an anti-racist curriculum, but it's also tied to a number of the larger structural things that I think many of us are aware of in legal education. And sometimes, you know, again, in my own personal efforts, trying to codify what I understand as the workloads, right? Reading the faculty policy and then saying, okay, as an operational matter, here's how the Office of Academic Affairs is going to put this into place for a number of courses, for scheduling, and use that as a discussion, right? To start to have a discussion about where are those inequities? Where is that burden falling unfairly? And then just continue to work through that.
Brandon, if I could add to that, when we decided to do this program, I put a call out for volunteers. We had over 50 people, faculty, students, alumni, many with relevant experience, all volunteered to help. So it really was a shared project. And kind of related to this, there was a question about, well, whose responsibility does this fall disproportionately on faculty of color? This is a shared responsibility that we all have as faculty. And the fact that we didn't learn this in law school is not an excuse for not having to learn it now and to meet the needs that our students have at this moment.
Thank you, both. I want to transition now to some of the questions in the Q&A, but before I do so, I'll just throw this out as a comment, not soliciting an answer because we don't have too much time left, which is that it's important for all of our institutions, not just the two of ours, but every institution, to ensure that faculty contributing to this work, which disproportionately, as Professor Ondersma reminded us, will be faculty of color, are rewarded for their efforts to contribute in this area, because we all know that you can develop courses and you can contribute time to meeting these institutional needs, which are really requirements of justice. And then that could have negative and adverse consequences on the diversity of the faculty itself, because it tends to have other kinds of implications for retention of faculty of color. So I just wanted to make that observation. And I now want to just ask a question that has been posed in the chat, which is, what efforts, if any, are we taking to ensure that vulnerable faculties, related to the comment I just made, are protected from anti-discrimination, or protected rather from discrimination? So I guess the question is what resources are available to institutions to help protect vulnerable faculty? As far as I know, I'm not sure that we have resources dedicated to that. Professor Ondersma and Dean Douglas, do you want to weigh in? Do we have resources dedicated to that?
Well, I don't think that we specifically have formulated resources for that, but of course, we have to keep in mind that there's Title VII that does protect any individual from discrimination based on race and several other protected classes. But the other thing that I wanted to add as well, in addition to changing the curriculum, right, we also have to provide opportunities for students to talk about implicit bias, microaggressions, all of those things that we unconsciously engage in, and sometimes it's conscious, but students need to also be educated about that, because I think that will help them during those discussions about race within the classroom. And so that's something that we have been doing at Rutgers with having the implicit bias training as a part of our orientation. And we've also done ongoing workshops on imposter syndrome, microaggressions, and other topics that they should be well versed in and understand those dynamics that impact the conversations that we do have due to the sensitivity.
Thank you, Dean Douglas. You know, we have 1 minute left for our panel. I just want to make the comment that part of the challenge around protecting vulnerable faculty is often, as in our institution at Rutgers, questions about faculty retention and what can be done about that, questions about promotion, they're handled at a higher level of the university administration than the law school itself. So it really requires that law schools work in cooperation with the larger university infrastructure and ecosystem, chancellors and presidents, depending upon the particular organizational chart of your institution, to ensure the faculty of color and faculty who are contributing to these issues are protected and are rewarded for it. So there's a lot of complexity there that needs to be addressed, I think, holistically, and we can't rest all of the burden on law schools themselves, even though we are called to do as much as possible to advance this agenda. So thank you to all of our panelists for this wonderful event. I'm going to turn it back over now to Michael Chachura to close out today's panel. Thank you.
So I just want to thank our panelists today, our previous panel and these panelists here right now. And thank you, Penn State, for joining us. And thank you to our Rutgers professors. Professor Paradise, thank you for moderating. We are going to post a recording on our Race in the Law Review website, which I popped in the chat earlier. So if you want to come visit back, and you can share that recording. So thank you everyone for being here today.
Thank you so much,
Thank you, Molly.
everybody.
Thank you, everyone.